Hello and welcome to Decoding Risk, where we give you expert insights on trending topics in the insurance industry. I'm your host, Edward Pronley, the Marketing Operations Manager here at Fusable, and today we're talking about the most recent unanimous Supreme Court decision in Montgomery versus Caribe Transport, and what that means for freight brokers and shippers moving forward. Joining us for our episode today is Larry Rabinovich, a partner at the Barclay Damon law firm, and Chad Krueger, our vice president and managing director of our risk intelligence here at Fusable. Welcome to you both.
Glad to be here.
Delighted.
Larry, would you mind, before we jump in, just giving us a brief kind of background of your history in the legal space for trucking?
Of course. So I've been at the Barclay Damon law firm in the New York City office since the summer of 2011. Before that, for 25 years, I was an attorney at the Schindel Cooper law firm, which was affiliated with one of the arms or legs, whatever you call it, of Fusable, Central Analysis Bureau. And the folks at Central Analysis, or CAB, as I understand you guys call it these days, and Schindel were the ones that taught me the business. I've been practicing in this area now for 40 years, to my utter astonishment. And one thing I've learned well is to read a case. And I've been reading the Montgomery versus Caribe case, and I've also been reading what other folks have been saying about the case. And I'm not sure that those always come to the same point.
Well, I think that's a great place to kind of get us started. So for listeners who are not lawyers, can you explain what exactly is going on with the Supreme Court decision and how we got here?
What I'm going to suggest we do, and I'm not avoiding your answer, but I'm going to give a little bit of an introduction or background, if I might.
Please do. Please do.
And then we will go back. We'll go back to 1980, and then maybe 2004, and then maybe 2014. But I thought we might start in 1905, when a gentleman named Charles Henry Robinson in Grand Forks, North Dakota, who had no idea what would happen 120 years in the future, created a wholesale brokerage that provided produce to customers in North Dakota and Minnesota. This is long before long-haul trucking was a thing. When I say the word Interstate Commerce Commission, I'm going to get some blank stares from people that are not my age.
But I know what it is.
Good man, Chad. But the interstate regulation of trucking didn't start until 1935, because there wasn't that much trucking, and certainly not that much interstate trucking. And when Charles Henry started this small wholesale brokerage, he relied primarily on trains. Interestingly, trains were regulated at the time, under certain circumstances, by the ICC to transport their products between cities. Well, Charles Henry's nice little small company in Grand Forks, North Dakota, has expanded a bit since then. It's now one of the largest freight brokerages in the world. And I thought that it might be useful sort of as to think about two stories side by side. One of them is the legal history, which we will get to in a minute, I promise, and the history of C.H. Robinson, because to an astonishing degree, I think the history of C.H. Robinson might help explain a lot about the history of the issue that the Supreme Court just decided. So that's a little bit unusual. So for those legal historians that happen to be listening in, this might be of some interest. In any event, the company grew by leaps and bounds, and I'm sure for some people that are new in the transportation industry, May 14th, 2026 might become a date of before and after, before Caribe and after Caribe. But for those of us that have been around a little bit longer, the key dividing point is 1980, which is when deregulation of the trucking industry becomes a big thing. In 1978, there was deregulation of the airline industry. Interestingly, the statute that's just the heart of our discussion, the F4A statute, is actually an aviation sort of statute initially, and it was expanded. In any event, deregulation started with the airline industry. In 1980, it was expanded to motor carriers, and all sorts of things which the ICC had imposed on the trucking industry began to to free up, and things which had been done a certain way for decades started to change. And one of them was a loosening of the way that freight brokers worked. And that's the beginning of aggregation and growth of these freight brokerage companies. Nobody in 1980, nobody had heard of a third-party logistics company. That term had not yet been invented. As I always tell my colleagues, my students, and my clients, the federal statute in 1935, which began to regulate interstate trucking, speaks only of three categories of entities in the industry. It speaks of motor carriers. We still have those. It speaks of freight brokers. We sort of have those. And it speaks of, believe it or not, freight forwarders. We still have some of those, but it's no longer an important part of the industry as it once was. It does not speak of third-party logistics companies. So continuing the story of C.H. Robinson, circa 1980, they begin to grow quickly. They do get motor carrier authority at some point, as well as broker authority. Circa 2003 and 2004, right about then, plaintiffs' lawyers, likely in reaction to this notion of growing, all of a sudden, brokers, which had once been mom-and-pop brokers, hiring mom-and-pop motor carriers, all of a sudden you had these national brokers, or 3PLs, which very often were many, many times the size of the carriers that they were hiring at the shippers they were dealing with. And all of a sudden, these large 3PLs or brokers became targets of plaintiffs. And C.H. Robinson certainly was among those targets and remains a target to this day, obviously. And plaintiffs' lawyers came up with a new theory. Now, we're going to talk about negligent hiring or negligent selection of motor carriers, which is, as I will show, been around for a while. But around this time, the plaintiff bar came up with the notion of maybe the broker, when they get this big, is responsible more directly as somebody who's supervising the drivers because they're calling the shots. And right around this period, 2003, 2004, you have the first lawsuits which allege that C.H. Robinson and other large 3PLs are vicariously liable. That's a lawyer's term. It means they're responsible for what the drivers are doing, just like the motor carrier itself is responsible for what the driver is doing. And I think, it is absolutely possible that it's a coincidence, but I follow the rule that unless proven, assume no coincidences. C.H. Robinson, right around 2003, 2004, gives up its motor carrier authority and becomes, which it had held for an extended period of time, I believe, and became solely a broker. So whether it was by design or otherwise, that makes it harder, although as we'll see, not impossible, for plaintiffs to argue that the broker is vicariously liable for the driver because we normally don't think in those ways. In any event, some of those cases begin to go the wrong way. That is, some courts, and leading to multi-million-dollar recoveries against some of these big 3PLs, some of these courts say, you know what, we think that under these circumstances, the plaintiff has been able to show that the broker is so dominating here and has imposed such conditions on the motor carrier that they are, in fact, vicariously responsible for the drivers. We're now talking 2011, 2012, so this period. And again, under the theory that there are no coincidences, right about that time, some very clever attorneys, one of them I know well and respect greatly, looked back at a statute that had been passed in 1994, right around the time that the Interstate Commerce Commission was about to itself go out of business as part of the deregulation effort, and said, you know what, if we look at this statute, by the way, the statute, for those keeping score, the statute is now found, and this was the statute at the heart of the Supreme Court case, 49 United States Code, section 14501. The new legislation is embedded in that section. But this was 20-year-old statute. No one had ever thought about this before because the statute was primarily aimed at making sure that the states didn't replace federal deregulation with state regulation. And some very clever lawyers said, well, if we read that statute carefully, or selectively is the way I would put it, you can come up with a theory that says that motor carriers can be liable to plaintiffs for tort actions, but maybe brokers can't. And they tried this argument out, and one case after another, courts began ruling that the broker was in fact going to be exempt from tort liability under state law because of this statute. Now, if we were dealing with a group of lawyers and we had the text in front of us, I would point out some unusual things about that argument, but this is neither the time or place for that. So let's just leave it at that and say, this argument began to sell. And for the last 10 years, there has been this buildup of courts around the country which have accepted the argument that you're not allowed or will not be successful if you try to sue a broker under state tort law because of this federal regulation which preempts the field. That's the argument. And we are therefore in a protected state if we are a broker getting sued in tort. It's not a perfect situation because this takes care of the negligent selection argument, but there may be other arguments against brokers. See if we can get to that a little later. But it's a perfect response to the problem of multi-million-dollar verdicts against brokers, which is can't sue brokers. The problem for the broker community is that there is one federal circuit court, the Ninth Circuit out in California, which has reached a different decision, which said you can sue brokers, again, because of an exception to the law that the Seventh and 11th Circuits, for instance, relied on to say you cannot sue brokers. So now we have a clash between federal circuits. The Seventh and 11th Circuit says you cannot sue brokers. The Ninth Circuit says that at least under some circumstances you can. And a case is decided in the summer of 2024. Seventh Circuit says we're in good shape. We've already told the community this, and they repeat it again, that a broker cannot be sued because the federal statute preempts it. And the plaintiff's lawyer is very disappointed and says, I'm going to take this case to the Supreme Court. And those of us that follow this yawned a little bit and said, all right, another try. The Supreme Court has ducked this issue repeatedly. They're not going to take this case. But, you wait and see. And here's the twist, and this is why I say the biography of C.H. Robinson just tracks this so completely. C.H. Robinson was the winner of the case in the district court and in the Seventh Circuit. And C.H. Robinson says, you know what? We would like to have unified case law on this. So we are agreeing with the plaintiff that the Supreme Court should take this case. Which is pretty unusual after you've won a case in circuit court. But the rationale is quite good because we're on a big winning streak here. Let's just make this the undisputed national law with the Supreme Court kicking in. And as my grandmother used to warn me, be careful what you wish for. Because here it is, C.H. Robinson got their wish. They got the case to the Supreme Court, which people had been trying to do for quite some time. And the Supreme Court rewarded them by shooting down the issue completely.
Yeah.
So preemption and F4A and brokers being exempt from state tort law is now dead. And C.H. Robinson, go ahead, Chad.
I've seen some articles where I think it was the CEO of C.H. Robinson right up until a couple of weeks before was very confident that this was going to go their direction. And I think it was in an earnings call or an investor call or something like that.
Well, let me tell you another story. I'm not going to reveal any names here, but we were at a mediation maybe a month or two ago, and terrible accident, 4 people killed. The motor carrier, which has only the primary policy, the policy didn't apply, but there was MCS 90 exposure, and the motor carrier said, this is a no-brainer. Of course, we'll pay our limits in exchange for release of the insured. And a large broker, let's leave it at that for now, large broker is a defendant here. And in such a case, particularly when you got 4 deaths, you can imagine the plaintiff's lawyer is hoping to get a lot of money from the broker. Again, this is not a small broker. This is a well-known national broker, presumably with many layers of insurance coverage. And the broker offered literally a pittance. Then I spoke to the mediator who was not aware of the case law, and I explained what was going on. But the broker's argument to the mediator was, look, the Supreme Court is about to free all of us from tort liability. So, you can take I don't know if they offered $100,000, whatever it was that they offered, take it now, because after the Supreme Court rules, which could be any day now, there's not going to be a penny for the plaintiffs, so they should really take it. Plaintiffs did not take it. They took door number 2, I guess, and Now I think the plaintiffs are feeling a lot better, and the broker is probably wishing that it had offered a little bit more money.
Well, so when we first started talking about this, first off, thank you for that history because C.H. Robinson clearly is involved in every aspect of this throughout history. So great to know and great foundation for what we're talking about today.
Yeah,
But I
and
remember, yeah,
historically, C.H. Robinson is a great company and a powerhouse in the industry, and they've done a lot of great things, but that intertwined history is just amazing, Larry.
By the way, C.H. Robinson, ironically, I'm not suggesting Machiavellianism here, but of of all the companies that are out there, many brokers, and we'll talk about what are brokers supposed to do now, and I can understand their concern, but frankly, of all the brokers in the universe, C.H. Robinson might be one of the best positioned to deal with the new scenario.
so I remember when I was first talking to you about this topic, I had asked you the question. I said, why was this case such a big deal for the trucking industry? And you responded with that you actually think it might not be that big of a deal for the trucking industry, at least in the short term. Would you be able to expand on that a little bit?
Sure. Let me give a little bit more of the parallel history now.
Yeah.
Which is, many of the articles that I've been seeing and podcasts and so on, the sense that I'm getting from many folks in listening to the podcast or reviewing comments that people make, on LinkedIn or other social media sources is, my God, how are we ever going to deal with this? This is such a game changer, and it's, most people think pretty horrible. I guess if you're in the plaintiff's bar, you think it's pretty good. So here's the thing. Remember, I mentioned my friend who circa 2014 dreamed up this argument that tort law is out of bounds when you're dealing with claims against brokers. Well, historically, that's just not true. I mean, this is a new development, and you go back to the 50s and 60s. Thinking back again, I've been doing this for, as you said, about 40 years, and over the years there have been cases against brokers. We have been successful at filing summary judgment motions over the years for brokers because, in theory at least, it's not easy to show. At least this is the way we all thought back in the 90s and the aughts, that it shouldn't be all that hard to show that the broker acted reasonably, and there's no basis for thinking that they did anything wrong. Now, I'm sure Chad will have some comments about the new universe we've got and some of the tools that brokers can now use because of the hullabaloo over this recent decision. But there's a case. Again, if I was talking with lawyers, I'd give you more details. But a Ninth Circuit decision from 1969 involving it was actually a shipper that made the selection. It was a shipment of steel, which is notoriously difficult to haul because unless you know what you're doing, you're not going to get the center of gravity right, and you might tie it down in the wrong way, and it's going to turn over. It's a mess. So don't hire somebody to haul steel unless they actually know what they're doing. Right? But that was the point of the Ninth Circuit. The Ninth Circuit said that we think there's enough evidence here to send the case to the jury as to whether the shipper of this steel spent enough time making sure that the motor carrier that they hired was capable of doing the job. Again, what happened in 1969 was the same thing that happens, every day of the week, which is, the shipper has a shipment that's ready to go. The carrier that they usually use to haul this sort of load tells them they can't do it today. So now they're scrambling, they're in a hurry, and when you're in a hurry, you make mistakes, right? So they reach out. There had been a broker that had come by a couple of months earlier to try to sell them work. They said, well, we don't really do this. We have a standard carrier we like. But someone said, find that business card. And they dug up the business card. They called the broker and say, hey, can you get someone over here real fast? And the guy said, sure. And, when you do that, things don't end up well. And sure enough, there was a bad accident. And the court said, under these circumstances, when you're dealing with a commodity that you really have to have some knowledge about how to tie it down properly and so on, you endanger the public by putting this in the hands of somebody that really was not capable of doing it. So under those circumstances, yes, your negligent selection potentially led to this loss, and you are subject to tort law if the jury concludes that you're negligent. So that's the law, until the F4A cases started to come down in the middle of let's say between 2015, give or take. Until that point, anyone who knew the history or knew what the law was would say, well, of course a shipper or a broker can be held liable for negligent selection. It didn't happen that often. And again, one of the reasons it didn't happen that often, I suspect, is that the plaintiff's bar was not focused on brokers, because brokers were pretty much small entities. Remember that as between the broker and the motor carrier, it's the motor carrier, and by the way, the Supreme Court made this point, it's the motor carrier that has the insurance obligation, right? A broker does not have a third-party insurance obligation, although obviously anyone who's listening now who represents or who owns a brokerage is probably doubling up and tripling up on their insurance coverages. But the federal government has a very limited requirement of insurance, and it's not for third parties, not for tort victims, for freight brokers. So the focus of plaintiffs' lawyers until this growth of the 3PL industry, the focus was always on the motor carrier, not on the brokers. So the short answer to your question is this a change for brokers? Well, sure. If you're thinking of the universe between, say, 2015 and 2025, this is a big deal, because for those 10 years, at least in certain jurisdictions, it looked like the brokers had an absolute buy. They were simply not subject to tort claims. But historically, that's an anomaly. That's not the way the universe normally exists. If you do something negligently, in most cases you're subject to tort recovery. But here there's a certain limited analogy here, which is until now brokers have just been off the chart. You cannot sue a broker, because if you try, you're going to be dismissed right away, or you should, at least in those jurisdictions. Now all of a sudden, lawyers who are defending brokers and their brokers who are going to be having to defend their practices will need to try different arguments and see how they pan out. Now, the next best thing to F4A bar would be a standard for summary judgment that everyone is clear about. But we're not going to get there right away. So it could be that 5 or 10 years from now, we will have built up enough of a case law to say, okay, if a broker does X, Y, and Z, then their lawyers will be in there's no guarantee here, but they'll be in a reasonably strong position to move for summary judgment and have some chance of success, as opposed to throwing the dice on a trial and hoping that the jury buys it, right? Right now, go ahead, Chad.
Yeah. So in the near term, what are the things that freight brokers and folks like that should be doing in order to put them in the best position if they are involved in a potential case or something like that?
I'm not in a position to offer legal advice, but here's what I do know, right? Is there really any way for a broker to know in advance which truck is going to be used for the load, and who the driver is going to be, and whether that vehicle appears on the policy that is listed with FMCSA as the current policy? That would be terrific if that's doable, but I don't know that that's doable. So this is the great uncertainty right now. I mean, there's going to be an industry standard which develops, and it's not going to be developed today, and it's not going to be developed tomorrow. This will be over some time. So we have two things that have to happen, and it's going to take a little bit of time. One thing is that there will grow to be some sort of universally, or at least industry-wide, agreed view of what proper precautions are before a broker hires a motor carrier, and how often you need to double check things. I mean, is the broker really expected to check before every load the 10-part test that the company develops to see whether this a safe carrier is still good? Do they do it once a month, once a week? Is IA going to be available to do that constantly for you, so we don't have to do it? So part A of this is going to be developments of industry standards, right? And as you know, Chad, maybe this be your future. There will be a cadre of experts that will testify at all these trials as to what the standard is, and that the company If you're the plaintiff's firm, you will explain that the company did not meet the standards, and if you're the defendant's expert, you'll say that the company did meet the standards. So that's part A of this, and then part B is going to be decisions by courts on summary judgment motions. Because again, any case that a jury decides is not relevant for lawyers in the next case, because jury decisions don't get reported, don't get written up. What's important for lawyers is decisions by courts on summary judgment, and then the appellate cases which review the district court decisions, which will come up with a body of case law which says, okay, if you do X, Y, and Z, whether it's going to be blue sky or just reasonable test based on a series of things which can be done. So I'm not here both because I wouldn't do it. I wouldn't want to be accused of giving legal advice, but much more importantly, because I'm not aware, no reason for me to be aware right now of what the best practices should be based on currently available software and so on. But there are people that do know that, and this is a standard. Again, I think we've wasted 10 years. Frankly, that may be a harsh way to look at it, but ironically, because we had a get out of jail free card, we've wasted 10 years, and there is no or very limited case law which explains, okay, how do we figure out whether the broker did a good job or not?
So, Larry, is there something in the older case law that might help us going forward?
So when I was reviewing cases, once the Montgomery decision came down, I did find something that we should all keep in mind. By the way, so actually two things. Number one, some of the cases decided right around the time that F4A was coming to the fore, which is this. Let's say that the motor carrier has a history of poor vehicle maintenance. That's the history. That's what's been flagged by the DOT inspectors over the years, right? So the plaintiff's lawyer jumps on that and says, hey, this is a terrible motor carrier. You should never have selected them because their maintenance of their vehicles is subpar. But let's say that the loss, that the case that actually is before the court, was one in which there was no maintenance problem with the vehicle at all. It was a driver that drove too fast, or it had something to do with a load that was not tied down properly, or something, in any event, something completely unrelated to vehicle maintenance. So this is a question of, do you tie together, is it necessary to tie together whatever it is that the motor carrier had shown weakness in the past, right, with the tort, or is it a good defense? And some of the case law suggested that it is a good defense, that it might be a perfectly good defense to argue that unless you can show that the weakness identified in the record keeping was causally related to this loss, it's not negligent. It's the causation is just not there. So what lawyers call proximate cause is missing, and without proximate cause, there's no actionable negligence. The fact that there's an accident doesn't mean that there was negligence in the hiring, right? So this is an area in which I think the industry is going to, and the lawyers defending the industry are going to want to go forward. I think so. Now half an hour later, I can come back to answer your question, which is this a really important case for truckers? Well, it may be important to the sense that, again, there are large 3PLs which mandate that in order to do business with them, the trucking company has to offer a hold harmless and an indemnification agreement, and that could be important. So sure, that to that extent. But in terms of standard liability, this doesn't change the liability of motor carriers. What it does is it restores the traditional scenario under which, a plaintiff's lawyer can sue a shipper, can sue a broker, can sue a motor carrier, and then the evidence will fall wherever it falls. So, I think the answer is I'm a little bit underwhelmed. By the way, the Supreme Court very often writes 80 to 100 page decisions, complication divided into subparts and so on. The decision in this case was just a few pages. It cited almost no case law. It was pretty much, as you read Justice Barrett's decision, pretty much saying, you really think that this statute passed in 1994 cuts off a broker's negligence exposure? We don't think so. Uh, Signed, Justice Barrett.
Yeah.
It almost sounds like the industry got away with one for a little while, but because they got away with it, they're actually kind of behind the eight ball.
I think that, Chad, I think that's exactly my understanding.
So, and that's kind of where we come into it. We've obviously, when you're familiar with us, but we work with many of the insurance carriers that are writing for that are writing the policies for the motor carriers, whether it be inland marine or auto liability or work comp or whatever it might be. In addition to that, they certainly work with a lot of the freight brokers out there. And we're getting a lot of the insurance carriers that we're working with that are talking to freight brokers, and the freight brokers like, gee whiz, what do we do? And the insurance carriers are looking at them and saying, hey, this is an example of a CAB report for one of the motor carriers that you put a load on, and there was an issue. So this is information that you have available. And that was kind of one of the things that always piqued my interest a little bit about this case, is that the freight brokers or 3PLs were arguing that we don't have access to the safety information to make a decision as to whether or not a motor carrier is safe or not. And again, whether people like it or not, the safety measurement system and the basic scores, to say nothing of the violation history for these motor carriers, is available and accessible out there, whether it be from Central Analysis Bureau, or other organizations, or from the motor carrier directly, to be able to make those decisions. So we're seeing a lot of those freight brokers reaching out to us, trying to understand what the difference is and what it is that we can provide to them. And my feeling in the process is that this is very similar to any other safety policy or safety program an organization might have. And whether you're a shipper or a freight broker, you need to decide what are the standards that you want out of the motor carriers that you're working with. Who are the motor carriers that you're going to put in the stable to be able to transport the goods for your clients, the shippers, and then be comfortable with that, and then follow your standard. You need to be able to follow that standard. And I would argue as well that some of these larger shippers out there probably need to lead by example, right? If they've got direct contracts with people, or they're subcontracting their loads to freight brokers, they need to set the standard as to who they're going to allow to transport their goods. And there's a good sized shipper that we work with that has done just that. And they've set the standard for all of their freight brokers, all of their motor carriers and things like that out there. And they use some of our data, other organizations' data as well too. And that's a case where the organization kind of needs to understand, what are the exposures, what are we comfortable with. And it's interesting that the industry wants the federal government to basically, you tell us who's safe, right? I would argue that the basic scores, the safety measurement system that's been around for over 15 years now, kind of does that a little bit. So I would encourage folks to consider that type of information, looking at motor carrier history, looking at the type of violations that they're having, and different things like that. And then be able to set your standards and to abide by those standards, because that, again, not being an attorney or giving legal advice, I guess, maybe I can because I'm not an attorney, but those are the types of things that will help make you defensible in court. So that's my advice, and that's where I think that the industry is going, especially in the short term.
And I think that's an excellent point. And as from what I'm hearing from Larry is that, industry standards aren't set yet because that case law hasn't been built up. And I feel like that means that freight brokers need to be a little extra careful, at least for the next couple of years here, and really make sure that they're vetting these carriers well. Would I be wrong to say that?
I think you got it exactly right.
I agree. I agree. There are options out there. We'd be happy to talk to anybody to help. That's what we do. We help educate the industry on this data, and we're here to help.
Well, Larry and Chad, thank you so much for joining us today. Any closing remarks that you want to give to the freight brokers and shippers out there?
Chad, go ahead.
Yeah, I think that if you're a freight broker or a shipper out there, this is definitely something that you need to pay attention to. You need to start looking at your options, understanding what information is available out there, and basically put your plan in place. Like I said, similar to a safety plan, a safety program, a risk mitigation plan, being able to put something together that you're comfortable with, and being able to stick to those standards in order to be able to ensure that you're able to be protected if worse comes to worse. And again, that argument that the information isn't available just doesn't hold water. It's available. It's out there. Give me a call. I'll show it to you. But we'll be happy to help.
Yeah, listen, the argument that that freight brokers have been making, to the extent they have been making the argument, is that, and that I'm not completely unsympathetic to the argument. The argument is that the federal government is allowing these motor carriers on the road. If they were really unsafe, the government shouldn't let them on the road. The difficulty, I think, with the argument is that with the derating, remember 1980, which for the old timers like me is sort of the breaking point. Until 1980, I think that argument was probably right. The ICC maintained really tough standards, and you couldn't just get into the business because you felt like it. These days, I don't. Chad can confirm this, I'm sure, but how many new entries are there every day into the system?
Between 500 and 700.
And nobody's checking any of these folks. There was a piece in Freight Waves the other day making the correct point that the insurance industry doesn't even do much underwriting anymore. Nobody's checking these folks. The government will, if you prove that you have insurance, which is granted without really any on-site inspections, the government will give you a license to be a interstate motor carrier. So, it really is economic interests and insurance interests which are maintaining the safety, because there's no gatekeeper anymore. The government pretty much lets anybody who wants to be a motor carrier do it. What percentage of motor carriers get inspected by FMCSA? How many of them have ratings at all, right?
And that's why the basic scores are so useful, because it's fresh last 24-month data. So
sure. Yeah. So the short answer is, I think it's probably unwise as a country for us simply to say, we're happy to let anybody get behind a truck if they can convince somebody to insure them. So one of the ways we do that is by having, this is the service. This is the first and only time you'll ever hear me say this, but this is the service provided to all of us citizens by plaintiffs' lawyers to put the fear of God into defendants and make sure that if you're running a trucking company, you know what the heck you're doing.
Absolutely.
Probably a good spot to end it.
Yeah. Thank you so much to both of you for joining us today and for bringing these expert insights into this topic. And just thank you so much. I really appreciate your time. Please stay tuned for our future episodes. Thank you very much.